Is it the truth? Is it fair to all concerned? Will it build goodwill and better friendships? Will it be beneficial to all concerned?
Thank you, Althea. Our speaker today really does not need a lengthy introduction. Judge Larry Stengel, now retired, has served our county and our country as a judge for nearly 3 decades. He was a Lancaster County judge for 14 years and a United States District Judge for 14 years, having served most recently as the Chief Judge for the Eastern District of Pennsylvania. Just recently, he returned to private practice as the CEO of Optimal Dispute Resolution, which provides alternative dispute resolution services. I'm not going to regale you with a shopping list of all of Larry's accomplishments, but I thought I would share with you a few things that perhaps you may not know and you can't learn from the bio in the transmitter. Almost 19 years ago, when I first went on the bench, Larry was assigned to the dubious task of being my mentor. I tell you that because that allows me to blame any bad work habits and poor decisions on Larry. If I've messed up in the last 19 years, it's Larry's fault. He must have been a bad teacher. It couldn't be my fault. As any judge will tell you, one of the most valuable assets of a judge, for a judge, is a good law clerk. A good law clerk is priceless. Let me let you in on a little secret. The clerks do all the work and we just take all the credit. When Larry left us and was appointed to the federal bench by President George W. Bush, one of the greatest gifts he gave me when he left was his former law clerk, Mary Ellen Glah. I could not possibly do all of what I do without her help. Thank you. So, how have Larry and I changed in the last 20 or so years? Well, I've had 3 rotator cuffs, back surgery, partial knee replacement, and so on. They have the technology. They can rebuild us. How has Larry changed? His hair is a little grayer. Please join me in welcoming one of the most widely respected former judges in this country, my friend Larry F. Stengel.
Thanks, Dave. If I can get this to work, we'll go somewhere. I want to thank you for the invitation to speak today. I got here a little early and saw so many friends as I was coming in the door and I was getting seated, and people have been coming up and you've been so gracious and welcoming. And for a speaker, that's actually a little terrifying because you know many of the people here and you'll run into them again. So with that backdrop, and I have so many friends in this group, I can tell you that in the community, this Rotary Club that meets every Wednesday is a gem and is well regarded and is considered to have some of our finest business and community leaders. And it's a privilege to spend a few minutes with you today to talk about what I've been doing over the last 14 or 15 years. Thank you, Dave, for that introduction. It was a privilege to serve as Dave's mentor judge. The Pennsylvania Conference of State Trial Judges had that program in place at the time. We got to be very good friends through that process, and that has remained now for nearly 20 years. Dave Ashworth is a judge's judge, and I know that from observing what's been going on in the Court of Common Pleas of Lancaster County. I know judges from around the state. I know judges now from around the country. His work in drug courts here in Lancaster County is, he is a leader in that specialty courts field. He's invited to speak and teach about drug courts. Those specialty courts really are the wave of the future in criminal justice. And your own Dave Ashworth is a national leader in that area. He has also handled a number of very complex cases with great ability, and his reputation in our profession is very, very high. I should also mention that my brother-in-law, Jamie Alton, is here. I got an email from Jamie this week. I was going to invite you to be the speaker at the Rotary, but Tom Gemmell beat me to it. So I'll come back, Jamie. We'll work something out. But we're enjoying. That's so. We're so happy to have Jamie as a part of our family, and so good to see him here. What I want to do today is talk about the federal courts. I want to talk about how they're organized and managed. I want to talk about some of the issues that come through the federal courts. I want to talk a little bit about judicial selection, both in the federal and state level. I know we have some time issues, so we may not go too deeply into that. And then I'm going to talk just very briefly about some current issues in the judiciary, and I'm happy to answer any questions you have at any time. If you want to interrupt me and ask a question, please feel free to do so. Yeah, I'd be happy to do that. My MO is I figure if I talk long enough, I'll have anesthetized you with a lecture, and you won't ask any difficult questions. So we'll see how that goes. Is this going to work? Oh, we have to turn it on, Larry. There we go. Okay. So the whole federal courts emanate from Federalist 78, Alexander Hamilton's treatise that he published in the process of having the Constitution considered by the then 13 states and ratified. Federalist 78 really sets the groundwork for the federal judiciary. Alexander Hamilton was the big proponent of the judiciary as we know it today. He referred to it as the weakest branch. It is not involved in politics, and it really is. It is that branch of the government that is essentially passive. The executive sees issues and they can investigate and they can make changes. The legislature can look into societal problems, transportation, taxation, defense, environment, and they're activists. They can go out and they can do things, but the judiciary is passive. The judiciary doesn't really do anything unless someone brings it to the courthouse steps, and then we do something. I've noticed I've been in private practice now for 4 weeks. It's been 29 years. I feel like I've stepped onto another planet, frankly, but it's a wonderful change. But I've noticed the difference when you're a judge and you get a new case. You open the folder and you say, "This looks like an interesting case. Let's see what they do." All right? When you're an attorney and someone comes in and you open up a file, you look at the file and you say, "This is an interesting case. I better do something." So the courts are essentially passive. They present the power to judge, not to act. No influence over defense or spending. No influence over the sword or the purse. Alexander Hamilton thought the separation of powers was that excellent rule, that was something that we needed to really preserve. He was the one who suggested lifetime appointments in the interest of judicial independence. And there's a quote in there that I actually put this PowerPoint together before the last couple of weeks, and I think this bullet point that's a quote from Federalist 78 really is so great. He says, "There's reason to fear that the pestilent breath of faction may poison the fountains of justice." And we're getting a lot of that pestilent breath of faction in the news today. All right, and finally, Alexander Hamilton was the proponent of judicial review. Now, Chief Justice Marshall gets a lot of credit for that in Marbury versus Madison, where the Supreme Court decided that the Supreme Court would be the final word in the interpretation of our laws. But that really was a seed planted by Alexander Hamilton in his notion that judicial review would be the last word in the interpretation of statutes or the Constitution. Of course, we're all about the delivery of justice. A couple of quotes about the importance of justice. And then I wanted to talk just a little bit about the structure of the federal courts. I was in the United States District Court for the Eastern District of Pennsylvania. That sits in Philadelphia with courthouses in Reading, Allentown, and Easton. We are one of 94 district courts in the country. All right, so there are 94 federal district courts. Those are the trial courts around the country. In Pennsylvania, there are 3 districts. the middle, which sits in Harrisburg and Scranton, the Western District, which sits in Pittsburgh and Erie, and the Eastern District. I had those boxes shaded blue because most of the action in the federal system takes place on the left side of that chart. Okay, so the district courts are where trials occur, civil and criminal cases are handled. The appeals go up to the courts of appeals. There are 12 circuits, 11 numbered circuits, and in fact, they're on the next slide. The circuit courts are the intermediate courts of appeals in the federal system. They take appeals as of right. That means if you lose at the district court, you have a right to appeal to the circuit court, and then they dispose of the appeal. Appeals from the circuit courts then go to the Supreme Court, which only hears cases that the Supreme Court wants to hear. They hear them by petition for a writ of certiorari, and they handle about 60 or so cases a year. Some years it's a little higher, some years it's a little bit lower. As I said, the courts of appeals are really quite busy. They sit in panels of 3. In big cases, they sit in what is called an en banc session, where all the judges sit. But that's really where most of the action is in the district courts. There was, of course, the tax court, the United States Court of International Trade, which has a fabulous title. They sit in New York. Tim Stanso, who's the chief judge of the Court of International Trade, and I served on a national committee for a couple of years, and I would be with Tim. He's an effusive, delightful guy, and I would say to Tim every time we'd get together, Tim, what exactly is it that you do? And he would say, tariffs. We do tariffs. They were one of the original federal courts that there was a lot of shipping and receiving back in the colonial and early parts of our history, and so the Court of International Trade deals with that. The claims court hears cases involving actions against the government, and then of course there are the veterans and military courts. The United States Court of Appeals for the Federal Circuit also sits in Washington. They hear appeals in matters of intellectual property, so they hear patent, copyright, and trademark appeals. You can see where we are. We're here in the Third Circuit. The Third Circuit Court of Appeals oversees our jurisdiction. The Third Circuit consists of Pennsylvania, New Jersey, Delaware, and the Virgin Islands, and then you can see just how the rest of the circuits are laid out. There's always been a lot of controversy about the Ninth Circuit. As long as I've been an attorney, there have been articles and legislative initiatives to break up the Ninth Circuit. Why is that? The Ninth Circuit is vast geographically, and the problems that people have in northern Montana are sometimes different than the problems people have in San Francisco. There are very different legal issues. The other thing that the Ninth Circuit is in the vernacular is it tends to be a fairly liberal court, and so when you have a Republican majority, they want to break up the Ninth Circuit so that they can isolate San Francisco and LA and put all the others in their own circuit. In fact, about 3 weeks ago, the House Judiciary Committee passed a bill that would break up the Ninth Circuit. I don't know if that will actually go anywhere, but there was a series of legislative enactments that affected the courts. They added 52 new judgeships. They are trying to break up the federal court. And another interesting requirement in the new legislation is that they want to make the code of conduct that applies to Judge Ashworth and applied to me and applies to all judges, make that applicable to the Supreme Court, because the Supreme Court doesn't have a code of conduct that applies to them right now. They're just supposed to do it right because of who they are. The other thing that the new bill institutes is physical examinations for judges. One every 5 years when you're over 60. When you get over 70, it's every 2 years. When you're over 75, it's every year. And I don't know if that will go anywhere, but that's a very interesting development. And I'll talk a little bit about that later when I talk about the role of the chief judge in the district courts. So the Ninth Circuit, again, there's an effort to break it up. Who knows where that will go. So we'll talk about the overall governance of the judiciary. The judiciary is a branch of your government. In my judgment, it is the most functioning branch of your government. I have a little bit of a bias, but it really, the day-to-day, the courts function very well and function as they are supposed to function. The courts in the federal system are governed by an outfit called the Judicial Conference, right? So there is a governing body of the federal courts. The Judicial Conference is made up of the chief judge of each of the circuit courts, and then one district court judge who's selected by that circuit. So there are 28 because we have representatives from the Court of International Trade and Claims Court. So the 28 judges, they meet in March and September in a meeting that is chaired by the Chief Justice, and they make policy for the federal judiciary. They represent the federal judiciary. They adopt a budget. They go to Capitol Hill and ask the House and the Senate for our money, and they do such things as suggest to the Congress where we might need more resources in different parts of the country. For the last 3 years at the appointment of Chief Justice Roberts, I was the chair of the Judicial Resources Committee, which is a committee of the Judicial Conference, and so I got to attend these meetings in September and March and see firsthand how the Chief Justice conducts the business side of the federal courts. There is an administrative office. They are in the Thurgood Marshall Federal Judicial Center, which is that big, beautiful glass building that sits next to Union Station in Washington, if you're ever down in Washington. And there is a director who basically is the chief operating officer of the judiciary. He works on a daily basis with the Chief Justice because the Chief Justice is in charge of the legal business of the court, but also is in charge of the administrative side, IT, HR, and that kind of thing. Jim Duff is the director of the administrative office, very, very competent and bright guy. He oversees a $7.7 billion budget, right? So the budget of the federal courts is $7.7 billion. To put that in perspective for you, my younger brother Jim was for 8 years the global head of marketing for Procter & Gamble. He had a great career with the Procter & Gamble company. He's now retired and does consulting in the marketing field. But when he was the chief global marketing officer for Procter & Gamble, he oversaw an advertising budget of $8 billion. All right, so the entire judiciary runs on $7.7 billion. Procter & Gamble spends $8 billion, and that was probably 8 years ago, for advertising. So it kind of puts it in perspective. The administrative office has a number of different departments that administer HR, procurement, contracting. There are 94 district courts. There are, in most districts, probably half a dozen courthouses, so do the math. There are a lot of buildings. They don't own the buildings. They lease them from the GSA. That's an ongoing battle with how much rent the GSA gouges the judiciary for, but they're back and forth about that. And we have a legislative affairs department, and then the administrative office gives assistance to the courts. That's sort of a flow chart of all the administration, and I'm not supposed to put this in there because that's an internal document, so I'll just go right past it. No, but you can see the structure. The director is at the top, and we have a number of different departments. I want to just make a somewhat of an editorial comment at this point. In the 9 years I served on the Judicial Resources Committee, and the last 3 as the chair, I think I attended in excess of 45 meetings around the country having to do with the business of the judiciary and how the judiciary is governed. And we got to know quite a bit about the experience of judges in different parts of the country. So the experience of a federal judge in Brooklyn, say, is very different from the experience of a federal judge in Missoula, Montana. Or the experience of a judge in Philadelphia is very different from the experience of a judge in the border courts, Southern California, Arizona, New Mexico, Western Texas, okay? They're all paid the exact same money. That's set by statute. They apply the exact same law. Those are set by federal statutes and rules promulgated by the Supreme Court. So it's the same job no matter where you are. There's a The chief judge of the Ninth Circuit sits in Montana, and I was having a discussion with him one day, and I said, I look out my window on Independence Hall. He said, I look out my window on a herd of elk. And it's just, it's just very, very different. So the geographical differences are profound. All of these districts, all of these courthouses, and all the policy that affects them is driven by a bureaucracy within the administrative office. And I'm one of those people, having been steeped in the system for the last 14 years, who thinks bureaucrats are just fabulous, okay? There are some very, very hardworking, talented, underpaid, dedicated people who are driven not by the money, but by the mission. Every person that I encountered in the administrative office in the time I was involved in court governance was a dedicated, highly talented, truly professional person. So I know it's sort of the coin of the realm to criticize bureaucrats. Do you want a bureaucrat deciding your insurance? Do you want a bureaucrat doing this? My answer would be sure. All right, they're actually quite talented, and as I said, mission driven. Okay, what's next? In each circuit, remember we have 11 numbered circuits and the DC circuit. There are circuit councils. They administer the circuit business. Again, they make requests for new judges. They monitor caseloads, and they do they oversee complaints against judges. In the state court system, if there's a complaint, an ethical complaint against the judge, that goes to the Judicial Conduct Board, which then takes it to the Court of Judicial Discipline. In the federal system, all complaints go to the chief judge of the circuit and are litigated by the circuit council. We have in Washington something called the Federal Judicial Center. That is essentially a group of research folks. Many of them were or could be professors. They do judicial education. They do some fabulous programs for continuing judicial education and research for the courts. Each circuit has an executive. Margaret Wiegand is the executive in the Third Circuit, and they basically help the chief circuit judge oversee the business of the circuit. Local structures, each of the 94 districts and the magistrate court and the bankruptcy court in that district has a chief judge. I was the chief judge of the Eastern District for a year. The chief judge is not an elected position in the Court of Common Pleas. It's an elected position. In the federal system, it's the most senior person who's not yet 65 and can serve a term of 7 years unless you get to the age of 70. The chief judge, Harvey Bartle, when he was the chief judge, a good friend of mine, told me that being a chief judge is like being the overseer in a cemetery. You are above everyone else, but no one's listening. And that's really true, all right? It's everybody that you have supervisory power over has life tenure, so good luck getting really anything done except around the margins. I did a lot of refereeing of disputes about how many dollars we're going to spend on chambers renovations, and somebody else needs an additional law clerk, and all those things that go along with management. But the chief judge oversees court operations. We do long-range planning. Probably in the year that I was chief, about 60–70% of my time was on administrative work and not on legal business. We have a budget that we administer, and we oversee. We have a committee system, and just generally help the clerk, who is the CEO of the court, to manage the court. The Eastern District of Pennsylvania had the longest serving clerk of court in the federal judiciary's history. Mike Kunz, who was a really good guy, was the clerk of court from the mid-70s until the summer of 17, and then he resigned. I chaired the national search to find his replacement. We found Kate Barkman, who was an attorney and a court administrator in Pittsburgh. She's moved to Philadelphia. She's fabulous. We have overhauled our business model in the Eastern District, and we've brought in outside program auditing folks from the administrative office, and we've tried to up the game in the Eastern District and make the court even more accessible to those who use it. and a better experience for our jurors and our parties and our lawyers. So the clerk really sort of runs the show. Give you a little bit of just a profile of what an average court looks like. The Eastern District of Pennsylvania is the third largest federal court in the nation. The Southern District of New York, that's Manhattan. The Central District of California, that's LA, are bigger. We are tied with Chicago for third place. They determine that by the number of authorized judgeships. The Eastern District of Pennsylvania has 22 authorized judgeships. Right now we have 5 vacancies. So we have 17 active judges, 11 senior judges, and 10 magistrate judges plus 1 on recall, which is essentially the magistrate version of senior judges. We have 5 bankruptcy judges. We have 4 court units. We have a large clerk's office, 192 work in the clerk's office, 111 in chambers, 96 in probation. So it's a large operation. The budget for the Eastern District clerk's office is approximately $21 million, and for pretrial and probation, $9 million. So about $30 million to run the show in the courthouse in Philadelphia. Number of attorneys, you can see 34,258 attorneys admitted to practice in the Eastern District, so it's a busy place. We were one of the original federal courts with the Judiciary Act of 1789, and the Eastern District has had a long history. It's been sort of a model court historically, a number of innovative programs. We were known for many years as the premier MDL court. MDLs are the multi-district litigation cases where cases that are similar in nature that are filed around the country. The Supreme Court decided back in the 70s that it would be efficient to assign all those to one judge, and so we have a number of transferee judges in Philadelphia on those MDL cases. The MDLs really are a big part of what goes on in the federal courts now, and the Eastern District of Pennsylvania is one of the national leaders in processing MDLs. Just what's an MDL? The NFL concussion case is an MDL. Those are cases filed all over the country that were consolidated under Judge Brody in the Eastern District. All the asbestos cases were consolidated and assigned to Judge Rebrano in our court. For the lawyers in the audience, you might be interested in hearing this, the 30% of the litigation in the federal court system is in the MDL pod right now. So that's a lot of cases get processed in that way. Case filings, just really an overview here. In 2013, we had 10,000 civil cases. If you look at 2017, down to 7,000, all right? So filings are down in the civil side in the federal court. On the criminal side, 690 in 2013, stays about the same, dipped in 2016, and back up in 2017. That's expected to go back up with the new administration, all right? The last administration, Zane Meminger was the U.S. Attorney. The Eric Holder, President Obama approach was to focus more on terrorism, large international cases, and corruption cases, and they dialed back the federal prosecution of the what's really the coin of the realm in the federal courts, the guns and drug cases, okay? And the federal courts under U.S. Attorney Pat Meehan were adopting cases from the counties, and so their numbers were up substantially. With the new administration, the U.S. Attorney is Bill McSwain, former white-collar defense attorney from a large firm in Philadelphia, and he has told me that his emphasis is going to be on making the office run a little faster, bring more cases, and actually do more outreach to the counties. I've talked to Craig Stedman here over the last couple of years about the absolute lack of attention he was getting from the U.S. Attorney's Office. The U.S. Attorney's Office in the Eastern District was more, in the last administration, focused on matters concerning Philadelphia and matters concerning international trafficking and terrorism cases. And Bill McSwain is going to keep that emphasis, but build more of a relationship with the counties and assist the counties a little bit more in prosecuting these cases that have federal implications. Judicial selection, a little bit of that in the news today. Who's qualified? The Constitution provides for a federal judiciary. The federal judges are appointed by the President with the advice and consent of the Senate. We've seen the role of the Senate with the Senate Judiciary Committee. Once they're passed to the floor, the Senate debates and votes. Factors which influence that process: a recommendation by the candidates' home senators, American Bar Association ratings, politics of the President, politics of the Judiciary Committee, public opinion, this is actually something that a slide that I built for talking about federal district court nominations. When you get into the circuit court nominations and certainly the Supreme Court nominations, the recommendation of the home state senators really doesn't carry that much weight. But for jobs like mine, the recommendation of the home state senators is very critical and still is today. So if federal judges are appointed in Harrisburg or Philadelphia or Pittsburgh, Pat Toomey and Bob Casey have everything to say about that. Okay, so circuit courts, the White House counsel's office gets a little bit more involved. The senators are still involved, but it's about a 50-50 thing. With the Supreme Court, it's all White House driven. Judicial selection in Pennsylvania, as you know, we do elections, and the governor can appoint if there is a vacancy. There was some talk about the governor appointing for an existing vacancy right now. It doesn't appear that that's going to happen. And I went through that in 1990. I was appointed to fill an existing term. That just runs to the next municipal election. Factors which influence judicial elections: Bar Association rating, party endorsement, money these days, social media interest groups, voter turnout, ballot position, all those kinds of things that shouldn't have anything to do with anything, but they do tend to matter. Looking at the time, how are we doing for time? We have 15 minutes. Okay, so like 30 seconds on the history of judicial selection. In colonial America, 8 states placed appointment power in both houses of the state legislature, 2 with the governor, 3 with the governor with the consent of council. So it was basically not an elected position early on in the Republic. In 1812, Georgia was the first state to begin judicial elections. Indiana joined the Union. They elected their judges. The appointment system was under attack. It was thought to be the province of the privileged, and only people who knew people got those jobs. And so let's open it up to the electorate. By the Civil War, 24 of 34 states had an elected judiciary, and the problems with that were the candidates were largely chosen by party leaders, and the electorate was uninformed. So Roscoe Pound, in a famous speech to the ABA, talked about putting courts into politics and compelling judges to become politicians has destroyed the traditional respect for the bench, and that's 1906. Okay. Today, if you look at the way we select judges in Pennsylvania, the election system seems to work for the county court judges because people know who the candidates are. People are more familiar with who's running in the counties. People have no idea who's running statewide for Superior, Commonwealth, or Supreme Court. I can remember a time when I was on the bench in Lancaster County. We had lunch. We had a judges meeting every Tuesday. Lunch after the meeting, and one day we were having a meeting on election day, and it was a judicial election day, and we were talking about who was running. And in a room of judges, we couldn't come up with a sense of exactly who was running for all the offices around the country. So imagine that, people actually in the business. So what happens when you have an elected judiciary and people don't really know who the candidates are, then you have sort of an untoward influence of money, of social media, and all those things that influence the electorate. So William Howard Taft gave a speech to the Cincinnati Bar Association in 1913 calling it disgraceful to see men, I'm sure he meant men and women, campaigning for the state Supreme Court. So there was a Missouri plan in 1940 which started this whole notion of merit selection, merit selection in the Missouri plan, which really is sort of the Cadillac plan today. You have a permanent nonpartisan commission, lawyers and non-lawyers appointed by public and private officials. They give a list to the governor appoints, the Senate confirms, and then you can run them for retention 2 years later to see if they're any good. So and New Jersey does that, and New Jersey has a very, very strong state judiciary, particularly at the appellate level. Today, 16 states use a commission to assist the governor. 9 states use partisan elections. So, again, that's merit selection. Okay, so current issues and trends. We have sentencing issues in the courts, there's a lot of talk about over-incarceration in the United States. There is an issue with racial disparity in our prisons. In Pennsylvania, about 12% of the population is minority. About 50% of the prison population is minority. There are issues to think about there. Of course, the whole process of judicial nominations, filling vacancies, allocating resources are significant issues. In the last 2 years, there's been a great deal of animosity between the executive and the judiciary at the federal level, with the president referring to a judge who I guess made a ruling on the travel ban as a so-called judge. I attended a judicial conference shortly after that. I can tell you the feeling in the room was not very friendly about those remarks. These are not so-called judges. Everybody who gets these jobs goes through a very careful and deliberate and thoughtful process. So you have that whole dynamic. And then finally, there's an issue with the expense of litigation. The number of trials is reducing significantly. I've actually moved into a mediation arbitration business because of my perception that there's a great market for that, that people don't want to spend hundreds of thousands of dollars and spend 3 and 4 and 5 years in litigation, that businesses want to resolve their problems. And if they can get to somebody who can listen to both sides and implement a plan and help them mediate that, that's a good thing. And I think that's catching on around the country because we have fewer and fewer civil trials. The cost keeps rising. Questions? I kind of blew through a few topics there. Hopefully you're numbed up and can't ask me any difficult questions, but I'm happy to answer any questions that you might have. Chet.
I was wondering if you think our judicial system in terms of tort reform might merit some attention, and how does our judicial system generally compare to Western Europe, especially the United Kingdom?
Okay. Our judicial system comes from the United Kingdom. We inherited their system of common law. They have a different jury structure than we have. A number of their cases are heard by the bench, not by juries, and they have much less of they have much less discovery and much less motions practice. More cases get resolved in the courts. I can tell you that there are mediation services in this country that have opened offices in London because there's an interest in England and in France, actually, in having American mediators introduce concepts of mediation in those courts. So, but that's, in terms of tort reform, I hear very little about tort reform right now. We tried that. That took us to the M-Care statute, and there was some modest reformation in the medical malpractice area, which I think was to the good. But in terms of limiting attorneys' fee percentages, in terms of putting caps on damages, there doesn't seem to be much political will for that, and that's where that would come from. So,
Larry, could you reflect on the Federalist Society, its founding and evolution, and its effect on judge selection today?
Sure, that's a great question. The Federalist Society is an organization of largely conservative judges, lawyers, and legal scholars. And there's a guy named Leonard Leo, who's the executive director. You may have seen him in the news somewhat. They're They've been around for a number of years. They have grown, I think, exponentially in the last 10 years. And there are some very fine people active in the Federalist Society. I can tell you that it appears to me that the current administration has outsourced the judicial selection process to the Federalist Society. They are very, very active in the suggestion of candidates to the Trump administration. So that's, you know, we have 3 candidates in the Eastern District of Pennsylvania. One of them is the president of the Philadelphia chapter of the Federalist Society, which is not to say he's unqualified. He's actually a brilliant, you know, mid-40s experienced litigator at a big Philadelphia firm. But they do have a particular orientation toward the law. It is you would associate that with more of a conservative philosophy about the culture in general and about the role of the courts. Any other questions? Yes.
Thanks for coming out. One of the questions I always have when I go to vote on any of these, and you kind of touched on it a little bit, even statewide judges, I think we voted on, I forget how long ago now. How do you get information on who these people are, and other than going off of whatever they put in the paper endorsement? I always wondered that as I'm going through this one. I have no idea.
You really have to do your homework before the election. If you go into the voting booth without much preparation, you're looking at name recognition. You're looking at ballot position. You might be looking, some people just look at party endorsement. But you have to dig to find out about statewide judicial candidates before you go to vote. There are articles in the newspaper. I'm not aware that they have too many debates. There's not too much to see, but you really have to access, I would say, the newspapers in the major markets. And now LNP is one of the major newspapers in the Commonwealth. So there is information available, but it's very hard to find. I think you have to go out of your way to find it, and I think it makes that process very difficult.
My other question was, you didn't really comment on any of the cases that you saw coming through at the U.S. Federal side of things. I'm just curious, what would be one of the trickiest cases that you feel like was very difficult, and what principles did you use to try to say, here's what I'll come out on this in terms of philosophy?
Sure. In the federal court, we have about half of the caseload is criminal, half of it is civil. Most of the civil cases are motions practice. Very few of them go to trial, and they run the gamut from patent, trademark, trade secret, antitrust. About 25 to 30% of the civil docket in the federal courts right now is employment discrimination cases, age, gender, race. We have a number of civil rights cases, and on the criminal side, we run a number of gun and drug cases. A lot of sex trafficking, child pornography is a large part of what the federal courts do now, given the extraordinary investigative efforts that the FBI engages in on the internet. And we have a number of political corruption cases and fraud cases. I think some of the most difficult are the fraud cases. You know, they're tedious, they're document centered, so the trials take a long time. The sentencing in those cases, I think, is very difficult because it's sometimes difficult to actually ascertain what the total amount of the loss is. I know in a case involving a prominent attorney from up in the Lehigh Valley, I held a 3-day sentencing hearing on a massive tax and mail fraud case. The defendant had an accountant expert, the government had an accountant expert, and as a former English major, I hired an accountant. So the court paid for an accountant to help me understand the other 2 accountants, and so you have to access resources available to you and work your way through those decisions. Yeah. Any other questions? Thank you very much.